Hey there, this is attorney Sarah Holmes of Holmes Business Law P.C. We are a business and trademark law firm that also offers general counsel subscription services to business owners. One question we get, how do I handle a legal dispute in my business? So we deal with clients all the time that have legal disputes. Most of the time, our law firm does not handle litigation. Sometimes we do, so you should always reach out to see. Otherwise, we can give you a referral. But our main goal in our law firm is to help business owners avoid litigation as much as possible. Why do we want to do that? Shouldn't I go litigate and enforce my rights? Sometimes the answer to that is yes, you should litigate and enforce your rights, but many times the answer to that is how much do you want to spend proving you're right? While you can get legal relief in court and by suing someone and being successful in a lawsuit, chances are that can cost you a lot of money. If you are traditionally involved in a business dispute, like let's say you have to sue someone on a contract for money they owe you, that typically is not work done on a contingency fee. That is typically work that the law firm will bill you hourly for. The reason for that is those types of cases are not backed by an insurance policy, such as like personal injury. That's why those cases are typically run on a contingency fee. Business litigation is almost never a contingency fee. So number one, you have to be prepared to spend a lot of money litigating. So to the extent you want to avoid litigation and maybe settle a dispute before it gets that far, what should you do? All right, well, number one is if the dispute involves a contract, you need to pull that contract out ASAP and figure out what it says in terms of when the parties enter into a dispute. So some contracts actually have dispute resolution clauses in them. A dispute resolution clause might say what the parties are going to do to try to resolve the dispute before litigation is filed. So it may have a mediation clause. It may say something like the parties agree to friendly mediation before pursuing this further. It may have an arbitration clause. The arbitration clause may say both parties agree to give up their rights to file a lawsuit in court, and instead they're going to go hire a private arbitration panel to hear this dispute, and they agree that that result will be binding. So you really have to read the language in the contract carefully because you're going to be beholden to the language in the contract that you signed off on as a business owner. Now, the other important part is the contracts will also typically say where disputes have to be heard and what law applies. So if you had a contract with someone in another state, you need to figure out if you actually have to go to the other state and handle that dispute with them if you're going to file a lawsuit or go to mediation or arbitration, and you want to know what state's laws apply. Because if your regular business attorney is in one state and you have to go to another state and actually litigate that case or arbitrate it, you're going to need counsel most likely in that new state. So pull those items out and figure out what's involved with litigation. Once you're armed with that information, meaning you know what the consequences are of not being able to resolve this dispute with someone else, now you can go figure out a strategy for actually working with the other side to resolve it. So you always want to know in a negotiation what's your leverage. So the leverage is typically what does the other person want and what am I willing to give and what do I want in return. And it's really just finessing that back and forth in terms of how does this other person get enough what they want to agree to resolve this dispute? How do I get enough of what I want to agree to resolve this dispute? And in the end, there is some compromise, and that compromise might look like saving money and not litigating, and the compromise might look like maybe you get a faster resolution, right? Litigation sometimes can take several years, even an arbitration could take a long time. And really, to get any type of clarity, it would be best for the parties most of the time to come up with a way to resolve something on their own. So those are always your initial steps if you have a business dispute with someone. Of course, if you want to reach out to our office for some help, you can feel free to call us 215-482-0285. And also for business owners, we have a really handy business protection legal checklist available that you can download in the link below. Thanks.